Okay, Jawad, I think it's 10:34. Should
Yeah, let's start.
okay. Thank you everybody for joining. I know this is a Thanksgiving weekend here in United States, but thank you for taking time and joining this important conversation today. This panel is organized by Foundation, the London Story Netherlands based, and Indian American Muslim Council, US based, and along with the University of Groningen, Netherlands. The panel theme is hate speech, hate crime, and the possible legal violations. As you all know, hate speech, the Cambridge Dictionary, as well as the more popular dictionary, Wikipedia. I was reading what's the classic definition of hate speech is defined by the Cambridge Dictionary as public speech that expresses hate or encourages violence towards a person or group based on something such as race, religion, sex, or sexual orientation. Hate speech is usually thought to include communications of animosity or disparagement of an individual or a group on account of a group characteristic such as race, color, national origin, sex, disability, religion, or sexual orientation. There has been much debate over freedom of speech, and hate speech legislation. The laws of some countries describe hate speech as a speech, gestures, conduct, writing, or displays that incite violence or prejudicial actions against a group or individuals on the basis of their membership in the group, or which disparage or intimidate a group or individuals on the basis of their membership in the group. The law may identify a group based on certain characteristics. In some countries, hate speech is not a legal term. Additionally, in some countries, including the United States, much of what falls under the category of hate speech is constitutionally protected. In other countries, a victim of hate speech may seek redress under civil law, criminal law, or both. A majority of developed democracies have laws that restrict hate speech, including Australia, Denmark, France, Germany, India, South Africa, Sweden, New Zealand, and the United Kingdom. The United States does not have hate speech laws since the US Supreme Court has repeatedly ruled that laws criminalizing hate speech violate the guarantee to freedom of speech contained in the First Amendment to the US Constitutions. But we will get into these details because we have some amazing panel who would get into these subjects a lot more eloquently and deep than I could go. But before that, I will invite Dr. Ritumbra Manavi, who will moderate today's panel discussion. She is an assistant professor at the University of Groningen and the executive director of Foundation London Story, where her work revolves around hate speech and hate crime. She looks at how the hateful narrative contributes to creating social other and dehumanizing minority and vulnerable groups. Dr. Manavi has also conducted intensive research on the construction of citizenship in Assam as a Commonwealth scholar at the University of Edinburgh. Her work in Assam looks at the narrative of illegal Bangladeshi migrant and its influence on disenfranchising and dehumanizing communities that exhibit deep social, economic, and geographical vulnerability. Through geo-visualization, she shows that the state in Assam has regularly created disenfranchised citizens, D-voters, in areas worst affected by floods. She argues that in a warming world, the victims of climate change are created by the collusion of the state, which continues to deprive citizens of their power. This deprivation is deeply tied to communal and ethnic identities, which is characteristic of structural violence embodied within state apparatus. She believes that the welfare, facade of welfare policies and state care fails to deliver because those worst affected may not even have a right to have a right. With that, Dr. Manavi, this is yours.
Thank you, Rashid Ahmed, and welcome everyone. Thank you for joining us today for this webinar.
on hate speech, hate crimes, and legal liabilities. We have with us 4 eminent legal scholars to reflect upon various aspects of hate speech and the current capacity of the law to govern it. My first speaker today is Professor Marcel Bruce. Professor Bruce is a renowned expert in public international law and chair of the at the Rijksuniversiteit Groningen. And he's also the chair of the Department of Social Science at the University College Groningen. Professor Bruce serves as the member of the Review Committee of Science and Ethics and is program director of research at Transboundary Legal Studies. He's also the editor of Netherlands International Law Review and has served as director of studies of the International Law Committee. Welcome, Professor Bruce. I would.
Thank you, Ritu. Good evening to all of you. And thank you for organizing this very important webinar. It is a privilege to be here and to speak to you and to share some of my interest and some of my views on hate speech. I'll do this from an international law point of view. I'm an international lawyer. I'm not specifically a human rights lawyer. I'm not an international criminal law lawyer. I am a generalist in international law, and I'm very interested in looking at what international law means, or what hate speech, how hate speech is how hate speech is addressed in international law. And I start with the next slide, please. I'm very happy that Ritumba is assisting me with the slides. So I started with one proposition, and that is a proposition that hate speech is prohibited in or by international law. That sounds like something very simple, but we stay with the proposition for a moment. The question is that a correct statement? Is hate speech prohibited in international law? And another question which we could think of is, what does it in fact mean if it is prohibited in international law? But it leads to a number of questions if we want to answer or tackle this proposition. And if you go to the next slide, I have put some of these questions which we have to ask ourselves in order to be able to see whether in international law hate speech is addressed and also sufficiently addressed. There's two main questions, of course, which we have to tackle. The first one is, of course, what is actually hate speech? We already heard some definitions and some ways of describing what hate speech is, like from a dictionary or from Wikipedia. But the main question is that in law, and certainly in international law, there is not yet a very clear definition of hate speech. There is all kind of working definitions, working descriptions of what we understand by hate speech, but there's not one single hate speech definition. That's good to keep in mind. I will not deal with the question so much in my presentation what hate speech is. I think the speakers after me do that much more with much more expertise. They can deal with those questions. I have put here a number of issues which are relevant to look at, and especially, and it was also addressed, how can we see what the dividing line is between hate speech and the freedom of expression? When are we going to limit people's freedom of expression because we consider it hate speech and it should be acted against? Important is therewith also to look at the forms and the impact of hate speech. The next question is what is international law? And that is also not knowing exactly what the audience of today's webinar is. It is very difficult to start somewhere. I cannot presume that everybody knows exactly what international law is and what its limitations are. And therefore, if we want to address the question, is hate speech addressed in international law, then we must also look at some characteristics of international law. Let's go to the next slide. And there's a lot of text here, and I'll talk you a little bit through it. It is also a reminder for you if you want to. It's recorded, so it's easy to see what is important elements. I put here down some core characteristics we should never lose sight of, and I'm quite sure that most of the people watching this know this, but it is good to bring it back to the fore. One thing for international law, which we should never forget, is that international law is a legal system which is very complicated because we are dealing with states, and states, they rely on state sovereignty. That means there's a limited role for overarching, for supranational or international bodies that can determine what the content of international law is, how international law is applied, and how it can be enforced. So states are the core of international law, and what states consent to, that will create international legal obligations. This is important in the context of hate speech discussions, because if states do not agree about what they consider hate speech, we'll find it very difficult to come up with specific legal instruments that first of all define what hate speech is, and secondly define also what obligations and rights the various participants in the international legal system have. If I say participants in the international legal system, the characteristic of international law is as well that it is, so far, there's a limited role for non-state actors. Non-state actors, that could be individuals, private persons, but that can also be companies, and also, like, for example, if we talk about hate speech in the social media, on internet, that can also be the big tech companies. They are non-state actors, and they do not have a formal role in international law. So that is good to keep in mind. But that's not the end to it. International law has some limitations. The state sovereignty is very important, but also there's more to that. And certainly, and that is very important to realize, that the current international legal order, let's say the post World War, Second World War legal order, since the mid of the 20th century, is based partly on taking a stand against the consequences of hate speech. If we think about what happened in the European continent with hate speech against Jews and other groups, and what consequences that had in the form of the genocide and crimes against humanity, that was a reason why the United Nations has been set up as it is, and why we have now so many new elements to international law, which I call here the common values, which through international organizations, the international community tries to realize. These common values, important in the field of related to hate speech, is the area of international peace and security in the world, and where we have the Security Council of the United Nations, who has even supranational powers to enforce these rules on international peace and security. These rules, we will see, can also be important for the very more extreme forms of hate speech, which lead or threaten to lead to mass atrocities, to atrocity crimes like genocide or crimes against humanity. The Security Council might be able to act against that. Another element where we see that international law has developed in order to tackle also issues like hate speech is that human rights have become a very shared value in the international community. And of course, we realize that many states breach human rights obligations, but the human rights developments are there. And within that, the freedom of speech, but also the limitations to that play an important role. There are conventions with standards, there's all kind of bodies created, And increasingly, what I mentioned is that there is discussion how human rights standards can also apply to international business enterprises. Also very relevant for further exploration when we speak about what can we do against, for example, hate speech through the internet. And finally, I would highlight here the field of international criminal law, which is indeed for the more extreme forms of hate speech, where it will be criminalized. And that has taken a huge step, and Professor Fournet will speak more about that, since the early 2000s, with, for example, the creation of the International Criminal Court, where breaches of individuals can be tried before such courts when they lead to international crimes. What we can see about these developments is that in international law, there are some limitations from state sovereignty. We see also the positive side of the development of the rules which try to promote common values. But we know that there's inherent limitations to what international law can do. So even if we come to a conclusion that hate speech is a topic which is addressed in international law, people should not think that through international law there are easy answers available. There are all kinds of inherent limitations to international law. Let's go to the next slide, please, Ritum. Now, how is hate speech addressed in international law? It is explicitly done so. There's two things or three things I would like to bring to your attention. A first role of international law, or a first role of law in general, is to create standards for behavior of the relevant actors. Standards so that they know what is allowed and what is not allowed. And we can see that with regard to hate speech, there are all kinds of specific standards developed, especially in human rights law. And I mentioned here the International Covenant of Civil and Political Rights, but there's also other international covenants where the issue of hate speech or incitement to violence or to discrimination are being addressed. And also where the explicit standards are is in international criminal law, where the incitement to genocide, and often that is done through hate speech, is criminalized and can be prosecuted either by national courts or by international courts and tribunals. So the standard setting for such more extreme crimes, there is international norms for that. These norms sometimes can be implemented at the international level, but we should also not forget that states are the most important, if you wish, organ of international law, because the rules, the standards of international law have to be implemented at the national level. So we can make a lot of rules internationally, but if states are not prepared to take them serious internally, then of course it is quite difficult. I've put with standard setting also another element, namely that of experts and special rapporteurs, because we have all kind of explicit binding international law, but we also see that there's a lot of new developments in making new laws and preparing the road for new standards. And I mentioned here the example of these special rapporteurs, for example, appointed by the United Nations to inform, to report to the international organizations, to the international community, what the current standards are, how they should be interpreted, and where we can make improvements to them. That's one thing, standard setting. The next thing is, and then we have, we are really speaking of international rules, but there's also more than rules in international law. International law is also more a general framework for international cooperation, international or regional cooperation. And in that international cooperation, that is working towards all kinds of policies on hate speech, but also in order to that international corporations in this international law framework, they try to, in that context, it is tried to gather information, to create the awareness, start a discussion on hate speech, on these issues which have not been addressed too much in the past. It may lead, and it has led in sometimes, to more specific guidelines for actors, for states, but also for non-state actors, to codes of conduct. And I mention a few of them here in this slide, and you must have read them by now. One of the most recent one is the UN Strategy and Action Plan on Hate Speech, which was released in September 2020, just only 2 months ago, where the United Nations, the Secretary General, has provided detailed guidelines for the UN in the field to keep an open eye for things like hate speech, and they have given them a toolbox. It's a very interesting document to look at. A toolbox how to identify hate speech and how to how to deal with that when you identify it. I can say much more about that, but we don't have the time for that. So I will go further. That is more specific, the international cooperation on the general frameworks where further action in that field will be developed. But we can even go a bit broader, and then we can look at the discussions, for example, and you have all heard of that probably as well, the UN Sustainable Development Goals, which also have a link to issues of hate speech, and also the responsibility to protect, a responsibility where there is a stronger international normative demand on states to make sure that they protect their citizens, rather than they only protect their own as a state and use sovereignty as a shield to protect from the outside. No, sovereignty is also a requirement on states to protect their own their own citizens. In many cases, that's not done, but that's also an ongoing discussion how we can improve that. And finally, I already mentioned it. It is very important to also include in these conversations, in these developments, the non-state actors. That's the businesses, but also the interest groups, the NGOs. Let's go to the next slide, and I will finish in 3 minutes. What is then important when we have these standards, when we have all kind of international cooperations, policy frameworks, action frameworks? That is also, when we have standards, we also must enforce that. And there's, of course, all kind of international human rights bodies who deal with these questions. We may come back to that after the presentation of the other speakers. There's the international courts and tribunals who can give enforcement to these standards. But also, and we should not forget that, it is not done too much, but the Security Council of the UN may also have a task in early action when in a country the situation deteriorates as a result of hate speech, and where there is, when a country is on the brink of breakdown and massive violence of groups of peoples against each other. I have mentioned here one peacekeeping mission to the Central African Republic, where in the mandate of that peacekeeping mission, very explicitly the topic of hate speech is addressed. So also in that context, we should be aware that that is also relevant. But again, I'll come back to that. We can look at all these international bodies, but finally the most important role is at the national level, through implementation, through criminal law and through civil law. You can take an action against another person if he voices all kind of hatred against you. A complex question is, how do we balance hate speech with the freedom of speech? And that is in the next slide. And that is what we'll probably see a lot of things in the follow the next presentations. I've tried to make here a graphic picture. In the red area, that's really where there's a high impact, incitement to mass crimes, there we have clear rules at the time in international criminal law and the field of peace and security. That's not allowed. That's prohibited in international law. We also have in the green line that in a democratic, certainly in a democratic society, we must accept certain expressions which some people do not like. There is some toleration also necessary. So that is the freedom of speech, which is under the human rights protection. But the more complex area is the middle orange. How do we distinguish a freedom of speech act from a hate speech act? And that is, we'll come back to that, I'm sure. And I will not spend too much time here now on that. We go to the next slide. So if I have proposition one, my answer is very clear. Yes, international law is dealing in very many ways with hate speech, but with a lot of limitations. There are some complexities which we just have mentioned. And also there's a need to cooperate with non-state actors if we want to make it effectively. It is not just making rules. It is also looking at causes and developing all kinds of action plans, policies to address these issues. It must be done at all levels. And then I go to the final, almost final one. I have a second proposition, and that is if we want to focus on hate speech, we should focus on I think two, but I add a third one. We should use all available means to where states violate already accepted international standards to exercise international pressures on these states. Secondly, we should work more to develop an international code of conduct, including a definition of hate speech, which can be used certainly for the use in limiting the social media. And thirdly, I think it's important that's also linking up to the project which Ruma is working on and with the IAMC is to identify issues of hate speech, to collect them, to analyze them, but also to store them, so that they can be used if the accumulation of a lot of hate speech leads to violence, so that we later can say, this is a response to early hate speech. We should not let that go. And with that, and the last slide, we will not discuss that. I leave that for discussion. And thank you for your attention. And I apologize for taking a little bit too much of the time. Lituma.
Thanks a lot, Professor Bruce. That was really informative. And thanks also for explaining nicely what the international law is about. With this, I would like to invite Professor Caroline Fournay to speak about the international criminal responsibilities and the hate speech. Professor Fournay is a globally known expert in international criminal law. She's a professor of comparative criminal law and international justice at the Department of Criminal Law and Criminology at the University of Groningen. She is editor-in-chief of International Criminal Law Review and co-editor of Journal of Human Remains and Violence. Professor Fournay has worked as a visiting professional at the International Criminal Court, and she has also co-investigated the multidisciplinary research program on corpses of genocide and mass violence. In her wide body of work, she has focused extensively on the crime of genocide, including incitement to genocide and genocide denial. Welcome, Professor Caroline.
Well, thank you so much. Thank you so much, Ritumbra, for this invitation, and thank you to all of you who organized this this webinar. So I think I will follow up, obviously, from Professor Bruce's presentation. There were mentions in there of international criminal law. And I will actually remind the sort of topic of my talk, is hate speech an international crime? Now the answer is very clear, and the answer is no. But I won't stop there because, you know, being a legal scholar, there are things to say and maybe things to interpret. And I will start with the following quote from Professor Rentlischer, who wrote, if hate speech is not protected under international law, as Professor Bruce very eloquently explained, it has never been established as a crime under international law. So that's the basic start for my presentation. It is not a crime under international law. However, looking at international criminal law, there are potentially two offenses in there which could, I'm being very cautious, cover hate speech. And these are direct and public incitement to commit genocide and persecutions. So I will go into these two categories of international crimes and highlight the similarities, but also the differences with hate speech. So the first one is direct and public incitement to commit genocide. Now, direct and public incitement to commit genocide differs from hate speech in several aspects. First, both acts belong to different categories of legal norms. Now, hate speech is, and other restrictions to freedom of expression, hate speech can be considered as a human rights violation. It can be considered as a crime under domestic law, and this I'll go back to this, but it's not encapsulated within international criminal law. Direct and public incitement to commit genocide, on the other hand, is encapsulated within international criminal law. So the two belong to different legal corpus. They are not regulated by the same legal norms. So that's for the first difference. The second one is that they do not correspond to the same criminal conduct. So basically, as the law stands today, to be very clear, hate speech is not direct and public incitement to commit genocide. Why? Because direct and public incitement to commit genocide must go beyond the promotion of hatred, which is actually what is in hate speech. They must go beyond this. It must incite and encourage directly the perpetration of genocide. So it really needs to be what it says, direct and public incitement. So it's a different criminal conduct. And linked to this, it's actually these two, hate speech and direct and public incitement to commit genocide, do not actually encapsulate the same criminal intent on the part of the perpetrators. Because for direct and public incitement to commit genocide, it's an inchoate crime under international criminal law, which means, and I here quote Professor Schabers, it's an incomplete crime. It can be committed even if the principal offense itself never takes place, but there needs to be the mental element of the perpetrator, which means that this direct and public incitement to commit genocide must be intentional. And there is this necessity for it to be carried out with this particular intent to destroy, or in whole or in part, one of the groups protected under the Genocide Convention, namely national, ethnic, racial, or religious group. So it's fairly limited in scope. It's a different conduct from hate speech in that it is more specific and it needs to directly incite to the criminal conduct. And there needs to be this intent to destroy. And the different tribunals have said it on different occasions, and they have highlighted that indeed, and I quote one particular case, the Akayesu case before the Rwanda tribunal, the tribunal said, the person who is inciting to commit genocide must have himself the specific intent to commit genocide, namely to destroy in whole or in part a national, ethnical, racial, or religious group as such, which we do not find in hate speech. And of course, this leads to another issue, which is an evidentiary issue. How will we prove this particular intent to destroy one of the protected groups? And this intent, it's widely known that it is extremely difficult to prove. And indeed, direct and public incitement to commit genocide will in fact be extremely difficult to prove. And again, the Tribunal for Rwanda has said on a number of occasions that without confessions of the accused, actually this intent to destroy will be almost impossible to prove. And sadly, it seems that to prove this intent, there might need to be a genocidal outcome. Namely, there might need to be victims. So it's not an element of the crime, and it's not an element of direct and public incitement to commit genocide, but short of actual physical acts of genocide, it will be extremely difficult to prove this direct and public incitement to commit genocide. So we have two distinct notions here. We have hate speech, a human rights violation, potentially a crime under domestic law, but hate speech is nowhere in international criminal law. What we have in international criminal law is this direct and public incitement to commit genocide. But again, it's very specific. It will be very difficult to prove. And reading into direct and public incitement to commit genocide hate speech would actually be abusive. Now, it has happened in the case law. There was one case that I will maybe finish on, actually, a case before the Tribunal for Rwanda, the Nahimana case, also known as the media case, in which indeed the tribunal sort of confused hate speech and direct and public incitement to commit genocide. And in this decision was quite criticized by the legal doctrine, but what was interesting is that the tribunal, to condemn these individuals for hate speech under international criminal law, actually interpreted international criminal law via the perspectives of human rights law. So this also fits in well with the multiplicity of international law responses that Professor Bruce was mentioning. But this remained an isolated instance, and the two are different. We have hate speech and we have direct and public incitement to commit genocide, which are distinct. Now, having said this, there is another conduct that is prescribed in international criminal law, and that is persecution as a crime against humanity. Now, the crime of persecution under international criminal law is, I was going to say it's a little bit of an oddity. It's not an oddity as such, but it's an obscure notion. It has been defined a bit vaguely by the different tribunals. I'll give you just an example. So persecution is a crime against humanity. And on different occasions, the Tribunal for Rwanda stated and ruled that persecution was the most abhorrent crime against humanity. So it was starting to create a hierarchy. In other cases, it said it has the same genus as genocide. So it linked the two. And in another case, it held that the crime of persecution is only one step away from genocide, which might read very well and be quite emphatic and quite a nice use of words, but in law, it doesn't translate very well. What does it mean? Persecution as a crime against humanity, only one step away from genocide? And the distinction between persecution and genocide is again one of intent, actually, to put it simply. Genocide, there needs to be an intent to destroy one of the protected groups. With persecution, it's an intent to discriminate. Now, persecution can be committed, can be recognized as a crime against humanity if committed under political, racial, national, ethnic, cultural, religious, gender, or any other impermissible grounds under international law. So it's quite wide. And here I'm quoting the Statute of the International Criminal Court, so the most recent definition that we have of persecution. So persecution can basically encapsulate these forms of discrimination on any grounds that are impermissible under international law. Now, having said this, there is also the requirement in the definition of the Rome Statute that this crime of persecution be linked to another crime. So it's not self-standing. And this also means that actually cases of persecution short of violence will actually not be considered as persecution under international criminal law. And in turn, this also means that hate speech will not be included within the crime of persecution. And again, I will quote Professor Rentlischer, and she explained, referring to the media case that I mentioned on the judgment issued by the Rwanda tribunal, where the tribunal confused between hate speech, direct and public incitement, and actually persecution. Professor Rentlischer wrote, Trial Chamber 1 here interpreted persecution to include hate speech, but that would not qualify as incitement to violence. In doing so, it expanded established law relating to crimes against humanity. So this idea that hate speech short of violence could fit in the crime of persecution is not one that was generally approved of in the legal doctrine. There is this idea that for the crime of persecution to be qualified as such, the speech, the criminal speech, must contain a call to action. We're back to this notion of incitement. And this stems from the Nuremberg precedent and the judgment against Julius Streicher, who had his publications in Der Stürmer with this propaganda, but also very clear calls to action in this propaganda. So to fit in this crime of persecution, again, we might need a very clear incitement. And this is where, of course, in practice, it can get complicated, because in a lot of cases, you might not have such direct call to action. And maybe the perpetrators will use different ways of expressing themselves, different euphemisms, different words, rather than a direct incitement and a direct call to action. And of course, we can discuss this extensively, but it is true that in the case law, in international criminal law, it seems clear that proving incitement is extremely complicated. And there was notably a case before the Yugoslavia tribunal, the Šešelj case. First instance, there was an acquittal. Then he was condemned, but again, he was condemned for his talk because the tribunal could see in this a direct incitation to commit the crime. And short of this direct incitation, incitement, the act might qualify as hate speech, but actually not as an international crime. Now, to sort of as a concluding remark, I would like to go back to the media case that was adjudicated by the Rwanda tribunal. Again, this is a case where it is an isolated instance where the defendants were found guilty for what was essentially hate speech, but this was qualified by the tribunal as direct and public incitement to commit genocide and also as persecution as a crime against humanity. So again, this was criticized in the legal doctrine, but it still remains a very interesting case in my view, because it is true that the tribunal here might have confused human rights law, probably domestic law, international criminal law, and made a little bit of a mix of all this to convict the defendants. Having said this, and probably, well, this will probably sound odd in you know, the words of a legal scholar, but there is the question that can be asked whether here the end justified the means. And this a bit pushy interpretation, was it actually justified? And I'll quote here the trial chamber in the case. Well, before I do this, just a little reminder, as we probably all know, the start of the genocide in Rwanda was with the downing of the plane of the then president. And in the Nahimana case, trial chamber 1 found, and I quote the trial chamber, that the defense contends that the downing of the president's plane and the death of President Habyarimana precipitated the killing of innocent Tutsi civilians. The chamber accepts that this moment in time served as a trigger for the events that followed. That is evident. But if the downing of the plane was the trigger, then the media, RTLM, Kangura, and CDR were the bullets in the gun. The trigger had such a deadly impact because the gun was loaded. The chamber therefore considers the killing of Tutsi civilians can be said to have resulted, at least in part, from the message of ethnic targeting for death that was clearly and effectively disseminated through the media before and after the 6th of April, 1994. So here, the trial chamber recognized with this expression, the bullets in the gun, the fact that yes, words can actually kill. Hate speech is not an international crime. The trial chamber undoubtedly embarked on a rather original, let's say, interpretation of international criminal law. It pushed for an extension of the crime of persecution and direct and public incitement to commit genocide, to include hate speech in there. But at the end, you know, at the end of the judgment, I was going to say at the end of the day, but here at the end of the judgment, the legacy of this judgment is the idea that sometimes words can indeed kill and destroy. And it's what they did in Rwanda, and it's what the tribunal punished on this occasion. This hasn't changed the law. So hate speech is still not recognized as an international crime. However, I'm also aware that in the title of my presentation, international was in brackets. And this has been already mentioned in the very introduction. Hate speech can be a crime within domestic criminal law. So maybe not an international one, but it can be a domestic crime. And I will end on this. Thank you very much.
Thanks a lot, Professor Caroline Frenet, for this insightful talk, and also about telling us very clearly what the limitations of the international law as it stands of now is. With this, I would like to invite Professor Jon Marijn. Professor Marijn will be speaking on populist speech restriction, and he will be highlighting how the European populist insistence on their own free speech, how they insist on their own free speech while curtailing the free speech of others. Professor Marijn is a well-known expert on European law and human rights. He's a commissioner at the Netherlands Institute for Human Rights and a chair of law and politics in international relations at the University of Groningen. Professor Marijn has worked as a civil servant at the Directorate of European and International Affairs of Ministry of Justice and Security, and at the Directorate of Constitutional Affairs and Legislation of the Ministry of Interior and Kingdom Relations in Netherlands. He acted as a Dutch permanent representation in Brussels for the Ministry of Interiors. Welcome, Professor Moran.
Many thanks, Ritu, for the invitation, and it's great to talk to so many different time zones at the same time. Should I share my own screen, or will you do that for me?
However you prefer.
Let me try to do it myself.
Okay.
Do you see the show like this? I see some nodding in a vertical direction, so I take that as a yes. So great to be invited. Thank you very much. I know that in Europe we're approaching dinner time, and in the US we're approaching lunchtime. So I decided to put a lot more pictures in my PowerPoint than Professor Ross did, simply to keep us going a little bit. What I'll be talking about is a bit related to my background that Ritu just mentioned already. It's more practical. I'm interested in populism and how it looks and feels like when you get close to this. And that's what I'll be want to talk to you about, specifically in relation to how the European Court of Human Rights has dealt with it, and perhaps how it could deal with it in the future to really get to the core of what populism is all about, and how populist speech and how populist speech restriction pose a real dilemma for a human rights court. So this is what my brief outline will be. I'll be talking about a quite well-known case related to free speech, a Polish case. I saw in the list of attendance that there's not really any Polish participants by judging by the surnames, but so I'll be giving you some background on that. I'll take Poland as a case study, simply because I've worked on that myself. So I'll discuss that case, and then I'll discuss another case that is currently pending against a colleague of ours called Wojciech Sadurski, who is a professor of legal theory both in Warsaw and Australia. And he used to be actually my own professor at the European University Institute when I studied in Florence at the to do my PhD. And then I'll link these two cases to try and make clear what is the challenge that populism poses for human rights protection, and specifically for the protection of free speech, because I think it does pose a specific challenge there. So let me introduce you first to somebody here. This is Jacek Kurski. Mr. Kurski is a politician in Poland, and I'll keep it general at this stage, and you'll understand later why. And as a politician, he was invited to a talk show, a quite famous talk show in Poland, where he got very angry with a particular newspaper, and he was waving the newspaper in the screen to everybody, complaining that they had published lies, and therefore that everything they had written about him and his party was based on a lie and was unworthy of being fit for print. Now, what happened was that this newspaper, Gazeta Wyborcza, which is basically one of the main liberal newspapers in Poland, got very upset with him, and they sued him for defamation. And this case went all the way up to the European Court of Human Rights. So this Polish politician Jacek Kurski sued the newspaper, or was sued by the newspaper, and he was actually in all the levels of all the three levels of Polish courts was convicted to pay a fine and publish an apology. And he brought this case up to the European Court of Human Rights, the Human Rights Court in Europe, complaining that by this action, by this newspaper, and by the way that was facilitated by the Polish legal system, in fact, his free speech rights had been violated. And what did the European Court of Human Rights reply to this? It said, I think you can read that on the slide with me, that the court considers that journalists and publicists, this newspaper, actively involved in public life should display a greater degree of tolerance for criticism against them. So if you're media, you should display a greater degree of tolerance to criticism. In a democratic system, the limits of permissible criticism are much wider than with regard to newspapers than in relation to private citizens. So as in the Netherlands, we have this proverb, high trees take more wind. You have a special role as a newspaper in the public debate, so you should also be able to deal with more firm criticism. They also made the case, the second point, that in fact this intervention by this Polish politician Jacek Kurski was itself a contribution to the public debate. He had not done his intervention in a private capacity. It was as a politician. And therefore, the court ruled that Poland had violated Article 10 of the European Convention on Human Rights, the human right that protects the free speech, by allowing these courts to convict Mr. Kurski. And this became a quite standard case about protection of reputation. And it's now even on the fact sheet of the European Court of Human Rights there, which is basically a sort of a handout that the court gives of all its own standard cases. So this is step one in my little story. Now let's continue to step two. This is Professor Wojciech Sadurski in a courtroom in Warsaw. And Wojciech Sadurski is here facing trial because he had been very critical in some tweets early last year. Why had he been critical? Because perhaps not many of you in listening to this are aware, but early last year, the mayor of Gdansk, which is a city in the north of Poland, was killed by some political extremists. And this was a result of a very virulent campaign against him in the media, because he was a member of the liberal opposition party. And after that happened, Wojciech Sadurski was very critical on Twitter, and he said that the current ruling party, the Law and Justice Party, should be compared to an organized criminal gang. And he was also very critical of the public TV station, saying that they compared to a Goebbelsian institution that you should never lend your voice to or never contribute to, because in fact all they send out is propaganda. So this led to Professor Sadurski being sued both by the head of the Law and Justice Party, Kaczynski, and the picture you see here that I took myself. I went to Warsaw to monitor the trial. He was tried for defamation of the head of this political party, which is generally considered a populist party, and he was also sued in a different campaign by the public TV station in Poland called DVP. And many NGOs have called this type of suits that have been brought against him SLAP suits. SLAP is an abbreviation of Strategic Lawsuit Against Public Participation. It's meant to silence your critics, and it is a way for the government to try and silence your critics. And one of the signs that this is in fact a SLAP case is that for the same tweet, the public TV station brought two different cases, a civil case and a criminal case. And in fact, today was one of the hearings in the civil case, and there will be a hearing in the criminal case a bit further down the road in next week. Now, because I knew this man, and because I firmly think that given the presidents that I just described in the Jacek Kurski case, this is clearly protected by free speech because he contributed to the public debate, and newspapers and public media should be much more tolerant of criticism of them. I started together with another academic from the United States at New York University a campaign with a hashtag called with Wojciech that gathered a lot of support all around the world. I launched this hashtag, and here you see a couple of examples of people who had supported this campaign all over the world by showing it at the beginning of conferences, by tweeting about it, by having pictures taken with this whole department, by the whole department. And we're showing our support simply because we want to show as academics that we're very much with Wojciech Sadurski as a public intellectual, and you should be protected by what you say in public, and specifically when you criticize powerful people, the media, politicians, you should simply be protected, and that's why we launched this campaign to support it. So you'll be thinking now, simply also because we're getting close to lunch and dinner time, so how are these things actually related in the first place? Am I just explaining two different cases where I explain one precedent by the European Court of Human Rights and now show you a case that is currently pending in Poland and may therefore benefit from that precedent? No, the story is very much about populists and how populists have a very different standards when they rely on free speech themselves and how they sue their critics. Because what is the story here, and you're not going to believe this. Jacek Kurski, the man who actually brought the case and that I started my talk about, is a very prominent politician of the Law and Justice Party that is currently in the government. And he is actually the politically appointed director of the public TV station that has sued our colleague Wojciech Sadurski. So just a couple of years ago, he brought the case all the way up to the European Court of Human Rights to protect his own free speech. And now he is suing, being the director of a public media company, one of his opponents. And I recently wrote a little piece about this called "The Plaintiff Who Turned into a Prosecutor." And you can find that under this link. If you Google my name and Verfassungsblog, you will find that piece. So the question here simply becomes, is this simply, and this is where I'll end my small talk, because I want it to be more of a reflection than a presentation. How can you insist on your own free speech and restrict that of your opponent at the same time, even if the facts are precisely identical? Is this simply purely cynicism? Or is there something deeper going on here? And how should you deal with this in terms of protecting free speech? I felt very disorientated by this, and I've been studying this for a number of years now, because it's really quite clear to a smart person like Jacek Kurski that he knows that he's going to lose this case when it goes to the Strasbourg court. So what is behind this? And is there something deeper going on in populists using their free speech and also restricting that of their opponents? My suggestion is that much research suggests that in fact there is something deeper going on, and that has to do with the specificity of populism, this us versus them kind of thinking. Because the playbook of populists and also the American-based colleagues will recognized some of this from day-to-day experience. Populists have basically a three-step playbook. They try to capture courts, mainly starting in the top. They try to capture public media, trying to really control it, simply because then you can control the message. Simply to give you an example of Poland specifically, this TV station that I just mentioned is a TV station that is the only available TV station in big parts of Poland, because there's a big divide between the rich part of Poland and the poorer part. And the TV station that is publicly financed is one, and that is actually the only available one in many of the poorer parts in Poland. So if you control that, you control the messaging to the whole population, and you can use it as a pure propaganda tool, which is what is now happening in Poland, unfortunately. And the third step is always tilting the electoral rules and try to see if you can somehow make a minority win a majority in parliament. Now, what is very typical of the more sophisticated populists is that they use the language of the law, and that's what is so disorientating about it. This takeover, it typically happens by using the language of legalese, as I call it here. A Polish government representative will not say, sorry, we're breaking the law. They will argue their case within the bounds of the law of free speech in the European Convention on Human Rights. If you go sit behind Wojciech Sadurski in one of these courtrooms in Warsaw, it's clear that they really think that they have an arguable case. And the reason why they think that, and that's basically my conclusion here, is that what they view as the rule of law is not how the rule of law is conceptualized generally by human rights courts. The rule of law and democracy are very closely linked in the doctrine of the European Court of Human Rights, by saying that the rule of law is not only about protecting the will of the majority, but also protecting at any time the interest of the minority. And that second part is always skipped by populists because of their conceptualization of this us versus them. Either you're with us or you're against us. And if you're against us, our rights don't apply to you. And that is the mindset from which Jacek Kurski could bring a case all the way up to Strasbourg, protecting his own free speech. And a couple of years later, when he was actually the CEO of a public of a media company in Poland, have no scruples whatsoever, and it was fully consistent in his own world, that he would sue one of his main critics in Poland, even if the facts seem to be copy-paste. So we have to be aware, and that's what I'm working on at the moment, is that if a populist talks about free speech and applies free speech rules, we have to be very aware that this is not in line with the way that the European Court of Human Rights itself had a notion of this when it made a standard case Poland against Kurski. What is happening is that there's some free riding on liberal democracy going on, and we have to be very aware of that. So this is what I wanted to explain to you from my own experience. And I look forward to the next presentation, and after that, the discussion with you. Thank you very much.
Thanks a lot, Professor Marijn. With this, I would introduce Dr. Waris Hussain. He's a professor at Harvard University, and he received his SJD from American University Washington College with specialization in constitutional and comparative law. Dr. Hussain has acted as senior staff attorney for South Asia and Southeast Asia at the American ABA, and has worked as a policy analyst at the US Commission on International Religious Freedom covering South Asia. In his compendium of work, Dr. Hussain has written widely about the process of judicial review in the Supreme Court of Pakistan, India, and United States. Today, Dr. Hussain will be speaking to us on majoritarianism and hate speech.
Yep, thank you. Can you hear me? Thumbs up if you can hear me, okay? Okay, perfect, yeah. Thank you to IAMC and to all of the hosts for today for raising this important discussion, and thanks to my fellow panelists for illuminating some of the most important points, I think, that relate to both international and European law that can play or have an impact on hate speech and hate crimes. I think from my perspective, or from my comments, I'll try and focus on the convergence between two issues, which is the digital proliferation of internet access in Asia in particular, and religious freedom, right? So that will impact our discussion on hate speech and hate crimes, especially in that region. And I think I'm going to take a more comparative sort of constitutional approach rather than taking an international legal approach, because of all of the wonderful comments that have been said that the international legal approach isn't necessarily as clear or as perhaps usable in the Asian context as we would maybe want it to be. So I'll try and take a more comparative approach and look at some of the laws of the countries that we have in Asia and how they're being used, and how solutions for digital problems or religious freedom problems that play out in the digital sphere are happening, and why they can be problematic. So again, I'll be focusing primarily on Asia and particularly on the Indian subcontinent as it relates to hate speech and hate crimes today. But it's also important to remember that these problems are global. As we've heard from our European partners here on the call, we know that these problems are happening in Europe, they're happening in Latin America, they're happening in Africa, but I'll try and focus, because of my expertise area or background area, I'll try and focus a little bit more on South Asia. So the first thing to start off with, I think, is that in the last 10 years, access to the internet has blown up in South Asia. We've gone from a 10 to 20% penetration to a 50% penetration rate, meaning that 50% of the people in this continent, the most populous continent in the world, have some form of access to the internet. And that's happened in the last 10 years. So that's a very fast pace for a lot of people to get online very, very fast, right? And so this has led to incredible phenomenon, especially in relation to interreligious harmony and religious freedom. So before I go into all of the bad things and how all of the bad guys are using digital tools to really, really put forward these populist, majoritarian sort of hateful rhetoric, I want to include some good things too, right? Because these sites have allowed for a lot of activists to work together to break down traditional sort of social barriers that might exist in real life and do those in online. So for example, a TikTok video showing a Hindu and a Muslim Indian having lunch together can actually bring a lot of smiles to people and actually have an impact on social discussion and narrative. So that's something we can't ignore. That's happening. At the same time, that's good news and that's great. And at the same time, the proliferated speed and access to communicate with people around the world presents opportunities to bad faith actors and religious bigots just as much as it does for the good guys, right? And they're going to use, and they have used social media to expand the reach of their message and turn their localized sort of populist messages, which is what we've been discussing in the previous panel discussions. I think they're using those local sort of campaigns, turning them into global campaigns, right? And they're using these digital tools to be able to do that. They're creating troll armies and troll farms to create inauthentic behavior to attack human rights defenders or people who are championing the causes of religious minorities. So all of these things are happening, and I think that's because the rate and speed of discussion has just increased, right? There's no way around that. And I think that's because the internet has proliferated so much in this subcontinent in particular. So while we have social and economic and political disenfranchisement of religious minorities that continues to persist and has persisted for centuries in the South Asian subcontinent, the speed and the reach of hate speech has now changed dramatically. So now the impact is that the rate of hate crimes is actually, I think, in some ways rising around the region, and things are getting a little bit hotter and more violent for individuals who belong to religious minority communities. So for example, in India's own Criminal Statistics Bureau has admitted that in the last 10 years, religious minorities like Muslims and Christians have faced a spike in hate crimes, actual mob killings, mob violence, actual assaults in real life. At the same time as we see the increased proliferation and the increased use of hate speech on digital media websites and social media websites. So we see both things happening at the same time. Hate speech in the digital front is expanding so fast that it's actually impacting real life in a much faster and quicker pace than it was ever before, because more people can get access to more internet, right? So again, good with the bad, right? And so we've seen that hate crimes are actually related to the hate speech that's happening. And we can't, I think, disassociate those, especially when we were hearing from the international criminal perspective and all of that stuff. I think we should take into account that for the Indian subcontinent, I think what we're seeing is an increased speed between something being said online as an incitement and actually something happening in real life, a mob attack happening on a Muslim neighborhood, Christians being attacked, ideas of love jihad being put forward, and all the other things that are being used to demonize Muslims and Christians, in particular in India. So we should keep those in mind. And I think with this extended reach, we've seen interrelated issues that allow for disinformation and hate speech to be proliferated and then cause real world harm. So I'll give you some examples. We have mob violence that's unleashed on religious minority communities and their neighborhoods based on fake news going viral through social media platforms. Let's not forget that the Rohingya were attacked in part because on Facebook, one of the most shared stories at one point was that the Rohingya were putting things into food in restaurants that they ran to make sure that non-Rohingyas couldn't have children, to sterilize people. That was a story that spread very fast on Facebook. And part of that was the reason why a lot of the Rohingya sort of communities, a lot of the non-Rohingya communities in Burma or Myanmar were sort of okay with some extreme actions being taken on them, because news like this is being shared, that they have this nefarious plot against us and they're trying to kill us off and sterilize our communities, right? So this is something that they're reacting to as a threat, completely fake, complete disinformation, but still being used and having real world impact. Then we have instances where there's a lot of access to internet, but there isn't internet education or digital education. So people understanding what's real, what's fake, how to vet a website, that's not something that's taught in schools. That's not something that's taught anywhere for internet users. And so that becomes an impediment for people to be able to critically look at the information sources they're getting through the digital media fronts, and then also balance the fact that they have more access to information, but then have the lack of capability to evaluate that information and to make sure that they can pick the right information that's actually true, right? So we have no digital education happening in a lot of ways. And then we have the persistence of inauthentic behavior online through social media companies, whether it's troll farmies, troll armies, troll farms, or troll armies that are employed by the state or by non-state actors. These individuals are engaged in online platforms and are able to mobilize. I'm sure many people on this call have had the troll armies of the RSS or the BJP come after them because they said, hey, maybe everyone should have equal rights in India. And that's enough for you to be targeted by the RSS and BJP digital armies. And that what happens is that then your account might be suspended because they're going to fake flag it to Twitter as spreading communal violence. You're going to receive hate speech in direct messages and in your mentions. You're going to receive death threats that might actually have an impact on your real life. These are all things that are going to happen to you. And these are all, the reason behind this, or the way in which this is being done, is through troll armies and troll farms that are paid. They're called 10-cent armies sometimes because for each tweet you give the person 10 cents or whatever it is. But essentially they're inauthentic armies that are made to attack people who are working to have equality or freedom in India or in Pakistan or other places. And for them, those human rights defenders or defenders to feel very, very threatened and want to stop their work, to have a chilling effect on that work. So that's also happening at the same time. And then the solutions that are being put in place by South Asian governments, there's a lot of solutions that they've tried. So we have internet shutdowns as one solution, where they shut down the internet completely if there's a fake news story being spread. We have website shutdowns, like for Pakistan, YouTube has been shut down because there was blasphemous content that was inspiring people to commit crimes. And so YouTube was shut down for a couple of years. We have content moderation by social media companies. So social media companies like Twitter or Facebook themselves will get complaints from users, oftentimes troll army users. And then they'll flag content or remove it or deprioritize it on their social media website, even though it doesn't really violate the terms of service, but it's being, the whole system of reporting is being manipulated by the bad guys, right? So we have content moderation by the social media companies. Then we have content moderation by the telecom authorities of India, of Pakistan, of Sri Lanka, who are ordering Facebook and Twitter to take down accounts, to take down information, and to take down posts that they find offensive or that they don't like very much themselves, right? So we have both social media companies taking down content based on their own terms of service and user reports, and also because of government demands for action. And then you have fake news laws that criminalize journalism or journalists who are sharing unverified stories. So fake news laws have been used in a lot of places like Singapore and other places, and they can have an impact. Now, I'll try and be brief in terms of sort of showing you how this plays out, but I'll go through shutdowns and I'll go through a couple other issues in particular. So I think one of the broadest tools that's used, and let's use Sri Lanka as an example. Sri Lanka had and has been suffering a great deal of communal sort of disharmony, conflicts in the past few years, and some would argue for the past few decades. And so what we had at one point is that there was several instances where fake news was being shared about the Muslim community, accusing them of the same kind of things that Rohingya were accused of, sterilizing people who are not Muslim, et cetera, doing terrorist actions, threatening the nationhood or the security of the state. All of those accusations were being shared on WhatsApp, Facebook, on different sort of modules, right, for communication, and there was a mounting pressure that there was going to be a mob attack, right, a mob violence, a lynch mob that was going to come to a neighborhood in Kandy or in other places in Sri Lanka as well that was Muslim dominated, and that they would burn down that neighborhood. There would be killings, there would be murders, there would be assaults. So in response to that, Sri Lanka shut down the internet. They just closed it down. They said, we're going to shut it down because this information, if it spreads more, this fake news, is actually going to cause a lot of damage to a lot of people, and there's going to be real world harm. So they shut it down. And actually, it did have a relatively positive impact, because with police being employed and with the internet being shut down, the temperature kind of went down a little bit, and they were able to handle that situation. Now, I say that by saying if you have cancer, chemotherapy is a very aggressive thing to use. This is almost on the level of chemotherapy to me. An internet shutdown can't be your solution to a common cold. Or rather, chemotherapy can't be your solution to a common cold. So I think what we're seeing with internet shutdowns is that even for small problems, small issues that actually the internet shutdown isn't helping, and in fact might be hurting, governments like India, Pakistan, and Sri Lanka are shutting down the internet. And they use the example of Sri Lanka to say, oh, well, this is a way that it's done correctly. But that's when Sri Lanka actually had proof and actually had sort of evidence and facts collected to say, okay, if we shut down for a very small period of time and take police action, we can actually protect this community. So what we see now increasingly is that internet shutdowns are being used more and more and more. Kashmir, for example, if you all know, for India, after the suspension of their autonomous status and political sort of issues that were arising there, the internet has been shut down for like almost a year. And so that's one way that they've done repression, and in the guise of state security, right? Just like Sri Lanka was doing it in the guise of communal harmony, India has done internet shutdowns in the guise of maintaining security. So I would say that it's a solution that has worked in the past, but it's a very, very extreme solution and can't be used for smaller issues, and other I think solutions would need to be employed for that. Another I think sub issue that we have here is that the shutdown of websites. So like I mentioned, for Pakistan had shut down YouTube for a while because of blasphemous content being shared there, and the Telecommunications Authority actually also goes to Facebook, goes to these social media companies, and asks them to take down the content or the users who are part of a religious minority community who are trying to challenge sort of limitations or discrimination they faced. And so what happens is actually a very Orwellian opposite of what happens. So essentially what the government does is that they see this person who's an activist who's trying to argue for equality, for example, for the Ahmadi Muslim community in Pakistan, and in response, the Telecommunication Authority goes to Facebook and says, this person is actually spreading communal harm and violence by talking about these issues, take them off the website. And because of Facebook's usual, or at least some of the social media companies' usual sort of acquiescence or acceptance or consent to a lot of the telecommunications requirements for different countries, they do it. So what we see is actually the bad guys are able to stay on the platform, do a lot of bad stuff, spread a lot of hate speech, spread a lot of content, whereas the good guys who are trying to spread good content, who are trying to engage their communities in a way that makes sense and pushes them towards a progressive equality for all the religious groups, they're actually the ones who are being silenced, whether it's through the telecommunications authorities or the social media companies themselves. The last thing I think I should mention here, in particular, because we've talked about genocide, we've talked about all of those things. I think with Myanmar or Burma, we know that Facebook has been called out directly, that the algorithm, that the actual programming in Facebook was rewarding content or prioritizing content that was hateful, that spread dehumanization language about the Rohingya, and that without Facebook, we may not have had the kind of violence carried out with the kind of acceptance from the Burmese public. So I think that's one of the last issues to look at, which is that how these social media companies themselves are regulating themselves, how governments are regulating them as well, in order to make sure that we don't allow for these companies to be, or these platforms and the internet access that's proliferated, to be used in a way that actually causes people to die or to be killed in mass atrocity events or genocides. And I would say the last point that I'll make, because we've mentioned this and I want to present the American perspective while being critical of the American perspective, I think the balance between free speech and hate speech is a really important question for the digital front. We're all confronting it. We all know it's important. There is a friction. I would really argue there's a real friction between the US interpretation of free speech and a lot of the rest of the world. American lawyers really have a preference for a free and unregulated marketplace of ideas. So they say, if we allow for hate speech, but that facilitates free speech, that's enough for us. That's okay for us. So long as this doesn't cross the line into incitement or trying to create real world harm for people, we'll allow for hate speech. I think that that's a unique, a very American sort of perspective in the way they balance the community's rights to equality, the religious community's rights to fairness, and free speech and hate speech. So I think all of these things are actually, for the US lawyers, fall into this marketplace and unregulated marketplace of ideas. And I think American lawyers focus really more on that question of, does this cause real world harm or violence? And if it doesn't, then we won't take action on it. But also, they often neglect American lawyers, and I'll be very honest, because as an American lawyer, I've worked with a lot of American lawyers who do this. They neglect the fact that the likelihood of harm between hate speech and hate crimes differs between countries, differs between times, differs between so many different aspects. It's not all how it is in America. And I think a lot of American lawyers look at, oh, well, you can say the N-word or other words that are really offensive, right, in America, and there might not be sort of a mass action where Black people are being killed in the streets, hundreds and hundreds at a time in a mass atrocity event. But that same kind of language that could be used in a different conflict-prone area that's really, really hot right now could actually have a very short fuse between that statement and what that incitement or what that violence is going to look like in the street. So I think that having an American perspective that looks at American society and assumes the rest of the world is just like the same is very, to be honest with you, neo-colonialist, very ineffectual, and doesn't really make sense. So when Facebook itself is led by American lawyers, right, they're going behind this perspective, and they're pushing this perspective as the American view on free speech, on how expansive it should be and how absolute it should be to the rest of the world. And they're also not thinking of ways to make not just global rules, because that's what they keep worrying about, but they also need to create localized rules that look at local communities, local sort of fact patterns, what the issues look like, and what's the fuse and how long is the fuse between speech being said online and a crime being committed. That fuse is different for every country and different for every year. India in 1984 or 86 may be in a different place where India is in 2020 today, right? So I think that even on time, we should be looking at a dynamic viewpoint, not a static viewpoint, and definitely not an American sort of viewpoint that really looks at and emphasizes the American culture and the way in which things happen in our societies. I think that's a very dangerous concept. And I think that's actually one of the reasons why we're having a really long lag time for us to figure out what is the international standards we need to be developing in terms of hate speech and free speech. I think the American lawyers are actually part of this problem, where because of their absolute perspective on this, oftentimes it actually gets in the way of actually having a conversation where we can learn from our European brothers and sisters, who, again, I think all the professors that we've heard from here, the Europeans were impacted by a Holocaust, right? One of the worst genocides in human history, and created laws domestically, not at the international level, but domestically, that can allow them to stop hate speech from turning into a mass atrocity event, right? And I think that same kind of idea is something that American lawyers can learn from. We may not have undergone the same thing, but it's something we can certainly learn from. So that's what I would put forward as my last argument, that as we do this sort of discussion, I think a comparative approach is so important for us to learn from our neighbors and for us to learn from our partners as we create these, and social media companies doing the same thing rather than just taking an American legal perspective would actually be very helpful in finding that hole for the thread to go through. Because I think we're really trying to thread the needle here, and it's a very hard sort of question to play out. But I think absolute perspectives, whichever side you're on, don't really create a conducive environment for creating an international or a standard that we can all work with in some way. So that's where I would end it, and I would thank you all for sort of hosting this discussion, and thank IAMC for the continued work they do for the Muslim community, in particular for India. I've worked with IAMC for several years now, and have always been so happy that they are fighting the really good fight, and oftentimes providing cover for me when I'm trying to critique the Indian government. They'll help me out sometimes. So I appreciate IAMC's solidarity and continued work. Thank you.
Thanks a lot, Dr. Varis. And yes, that was a really interesting talk and interesting overview of what's exactly happening in South Asia at this moment in time, and gives us a lot of food of thought. Now we are running over time, and I think that's because of my bad moderation, perhaps. But can I ask the panelists to just be there for another 10 minutes or so that we can take a few questions? Is that okay? Yeah? All right, great. So we have a couple of questions in Q&A, and I see Shahrukh here having Shahrukh Alam has a specific question for Dr. Forney and Dr. Moraine, that how do we factor in social political power while thinking about hate speech? Professor Morin, would you perhaps like to take that one because of the majoritarian hate speech component there?
Yeah, a hard question. I can answer, first of all, based on the current case law of the European Court of Human Rights. To some extent, political power and social power is already factored in that the standard of review or the scope of free speech varies depending on what the purpose of your intervention is and what sort of power you have in a society already. So if your purpose, as I explained, is to contribute to the public debate, and if your purpose is to do that as a politician, in fact, your free speech is wider, and also your willingness to confront often quite harsh criticism should also be wider. So how do we factor in that power in that? It depends on what sort of political power you're talking about. If it's a political power by a political party that actually accepts all the basic tenets of a liberal democracy, this is a good tool that the European Court of Human Rights has introduced, and these specific distinctions that I just made. If you're a populist, and that was the case I was making, this distinction doesn't really discipline you, because you can have your cake and eat it too. You can use the system of protection and misuse the system and the delay that it causes. It takes about a couple of years before you end up in Strasbourg, and the cost that you incur on somebody who you're actually trying to sue in a slap case. Just to give you the example of Wojciech Sadurski, if you run 3 simultaneous cases, 3 instances in Poland alone, before you end up in the European Court of Human Rights, where the answer is going to be obvious, you're going to incur massive lawyerly bills. So this is the political power can also, in that sense, be really misused, and is being misused simply to discipline the them in the us versus them, and that is what we're seeing now. So the system makes sense, but it presupposes that everybody accepts the basics of the rules. And the basic premise of the rule of law and democracy. And at the moment, the basic challenge of populists in Europe, and also talking about the Hungarian government, for example, is that they do speak legalese, but they do not accept the basics of these rules. And that's where that tension is, and what I called your attention to.
Caroline, would you like to also weigh in on this, on the role of
not,
power?
Not really. I couldn't really quite make the link with international criminal law in that question. So I think I'll leave it with the answer of the experts. So
all right, thank you.
May I make a small addition to this, or
yes,
give a small answer? I think one of the elements, it was mentioned also by Professor Morin, but in my presentation, I referred to the Rabat criteria in the action plan of Rabat. That's a number of specialists have drafted a set of criteria for distinguishing between what could be acceptable freedom of speech and what is then not acceptable, and which should be limited. And in these criteria, one of the criteria they mention is, for example, the speaker's position or his status. So it depends a little bit from what background the person making the speech act, where he comes from or she comes from, and what power he or she has behind him or her. It's also, there's other things like also the extent of the speech act. How far does it reach? Who is the audience? Who is targeted by it? Who can have access to it? So that's all elements to take into consideration in trying to find the balance between what is allowed and what is not allowed. There are more things which are relevant in this context, like intent of the speech, the context, but I cannot go through all the criteria. But I think that's part of a real problem which is addressed here, but it is also being addressed, at least at the international level, in trying to come up with some criteria which help us to find answers to these questions. Thank you.
Thanks a lot, Professor Marcel, for weighing in there. I think there's also a question for Dr. Hussain. When we talk about genocide and we are in 2020, suffering of Kashmiri and Indian Muslims, the latest example, would this be a case of genocide? And I would also like to know from Caroline if she thinks, would this be a case of genocide, especially what is happening in Kashmir with the violence there?
I think the genocide expert should speak first, so I'll let her go first. I defer to my learned colleague.
Thank you for this question. Well, as this is a really interesting question. Now you can have there's the law on genocide and there's international criminal law generally. Now the first thing I would like to stress is that genocide has a very strict definition. So it needs to be a certain category of act committed with the intent to destroy one of the protected groups. So that is genocide. Now, this means that for genocide, you need to, the group needs to fall within one of the protected groups, so national, racial, religious, and ethnic. It needs to be one of the prohibited acts, but usually it will be, violent acts, and you need to prove the intent to destroy. It is this intent to destroy which is extremely difficult to prove. And paradoxically, in the context of our discussion, some hate speech or some evidence of hate speech or of propaganda would actually help proving the intent to destroy, right? Because again, without confessions of the accused of it, or without the perpetrators of the crimes actually saying their plan out loud, proving this intent to destroy is extremely difficult. This explains why we have cases of mass violence that are not qualified as genocide, because the intent to destroy cannot be proven. If the intent to destroy cannot be proven, the acts will still be criminal. They will be crimes against humanity. And this is something I would like to stress, and I keep on stressing it. There is no hierarchy in international criminal law. So crimes against humanity and genocide are extremely grave crimes. They're just different because with genocide, there is this special intent to destroy. But if you have a look at the list of crimes against humanity, for instance, extermination, which is part of a widespread or systematic attack against the civilian population, well, it's obviously extremely grave, and as horrendous. So there is no hierarchy in international criminal law. And I'm saying this because very often there is this idea that genocide is the most serious, and that if it's not called genocide, it's not taken seriously. That is not the case at all. All instances of mass violence are extremely serious. They differ. So in the cases mentioned, what would need to be shown to have the qualification of genocide by a court of law is specifically this intent to destroy. And here, evidence of incitement to violence could actually contribute to proving the intent to destroy. Evidence of discrimination, which would take the form of persecution, would prove the intent to destroy. So again, we can have cases of mass violence and inherently hate crimes, but short of being able to prove the intent to destroy, these will still be criminal under international criminal law, but they will qualify as crimes against humanity rather than genocide. So the key is to prove the intent to destroy.
I was going to say, I agree with literally everything that was said. I think there's a distinction that one has to draw in their mind between, does it satisfy the elements of genocide? And then the second part, can that be effectuated at an international criminal tribunal or court, right? I think Professor Fournet is laying out to us the difficulties that international tribunal, not difficulties, but the proof positive that's needed to demonstrate to an international tribunal what is a genocide or not. Now, I think for our discussion purposes, I think we can definitely talk about early warning signs with the Kashmir revocation of autonomous status, with the kind of enforced disappearances that are happening in that region, with the kind of killings that have been happening in that region, with the kind of internet shutdown that's happening in that region, as well as with the kind of attacks that are happening by the Indian military forces against civilians. I think all of that is going to play into that distinction. And then we have the second part where we look at the statements, right? And we find out, is there actual intent here? And then you have, for example, Amit Shah, the leader of the BJP ruling party, saying that Muslims are termites and will expel them from the Bay of Bangladesh, right, or Bay of Bangla, right? Or we have, the CM, the chief minister of the Uttar Pradesh, every week making another kind of comment that there's some kind of green virus, a Muslim virus that's erupting in the UP. So these are dehumanizing sort of aspects that can help us prove and make sure that we know that the intent of what's happening behind this is dehumanization, is to try and vilify these individuals and people. And then you have, of course, actions that are taking place. But I do think that there's a lot of sort of limitations, not barriers or limitations, but maybe things that the international tribunals require proof for that we may not be there yet. But for early warning, which is not a court mandated analysis, that's an analysis that countries do, that multilateral institutions do. I think a lot of the boxes are being checked currently when it comes to these kinds of actions satisfying some of those elements. But I think the part of our discussion here that we want to, I think, emphasize as the legal sort of scholarship demonstrates is that the tribunals right now may not assess that, may not even take cognizance of this case. But the fact that we need to continue reporting, the fact that we need to continue collecting this data so that eventually that could be done and proven, especially if there's a mass atrocity event, something like the Delhi riots in a much more pronounced way, right? When it comes to the Babri Masjid rebuilding or something else that happens, it's a trigger point. It could be even elections, and this could create a very, very bad instance. So I would say, like, the last thing I would mention is that I am currently writing an article particularly on this for India's early warning signs for genocide that are happening, and so that will be coming out in the next few weeks, and I'll share that with IAMC's leadership. That can be shared with you all as well. But again, it's not even the analysis isn't a legally binding analysis, more looking at responsibility to protect as a framework, a theoretical framework, right? To be able to recognize perpetrators, to be able to recognize wrongdoers, and to be able to be on the front foot as soon as a mass atrocity happens, so the international community can move quickly to try and stop it and address it through the forums that they have.
And just as a quick follow-up, I just would like to point out that this is the paradox and the inherent limitation, at least in international criminal law, is that we can have these early warning signs, and then international criminal law will say, it sounds awful, but it's not enough, or it won't qualify as a crime. But then when we have a prosecution, they will look back at these events and say, oh yes, and these might actually qualify as persecution, which escalated into genocide, and the defendants might be found guilty for acts committing now. But right now, no one is listening to the early warnings. I mean, look what happened in Srebrenica, look what happened in Rwanda. How many times will we need to have these early warnings before actually, prevention happens? And I know this is not the topic, but genocide doesn't happen from one day to the next. There are clear early warning signs. Genocides can be prevented, and unless and until the international community listens to these early warning signs, well, it could prevent them, and it definitely should prevent them. So that was my little activist point.
May I briefly follow up on this, just a few sentences, because that is what
Yes.
I want to add to it. There's a different layer as well in international law. We can have the international criminal responsibility of individuals for committing these crimes, but there's also responsibilities and obligations on states to prevent it. Professor Fournet already mentioned the word prevention. It's all about trying to prevent that genocide or crimes against humanity happen. We have a genocide convention, and in that genocide convention, clearly there's an obligation on states to prevent genocide from happening. And that means taking early warnings seriously. The problem is, how do we hold to account states where these early signs can be seen, but they do not do anything. So internationally, there must be much more pressure on such states to act and to take their responsibility.
Thank you, Professor Bruce and Caroline. There's a related question actually on what Professor Bruce just said from YY that how do we define the timeline regarding hate speech in relation to crimes of genocide and crime against humanity? Because sometimes crime or violence does not happen due to single hate speech episode, but by a series perhaps. And it can be a accumulation of a long-term project or policy or system of the government by using different mediums. Sometimes they can be normalized in the society. How do we consider that while defining hate speech, or where do we go from here? And I have to say that there's also a similar question from Andrew Zoutma, who says that, do you think then that we might need to change the legal element of international criminal law on hate speech? And I think the intent to prove genocide, I think what the speaker the question means is that it is already too late if it is genocide. So can we prevent it already and define hate speech in such a way? Any of the panelists would like to take that?
I'll just very briefly, indeed, in the Genocide Convention, there is an obligation to prevent that is on states. Now, international criminal law with international criminal trials, just like in domestic law, it happens after the crime. You know, you have the trial once the crime is committed. Now, it doesn't mean we should not prevent, but maybe that's not the role of international criminal law to prevent the crimes. That's where we can have international law, responsibility of states, also responsibility of states under human rights law, because again, hate speech can be a violation of human rights. It can be also a crime under domestic law. But even, and I'll just say this briefly, with respect to genocide, even if the intent to destroy is very difficult to prove and it has been discussed and can be discussed over and over again, it still constitutes the essence of genocide. And I think, yes, the trials will happen once the crimes have been committed, but that's what happened with trials. So I don't think we should turn to international criminal law for prevention. However, we can turn to states, human rights law, and international law.
Thanks a lot, Professor Caroline. We do have some questions about how the civil society can contribute to this. Would anyone like to take that question? I know it's not a very personal legal question, but
I mean,
Boris, perhaps?
Yeah, I think this goes back to exactly what Professor Fournier was saying, documentation. The only way we can get actually, and I know that sounds awful, that it might take 10 years and it might take thousands of people dying. Well, I'm gonna let that sit there for a while, because I get that there's a moral issue that people take with that. And I agree with it. That's why we tried to create not just punishment, but the prevention of genocide. The Genocide Convention is called the Prevention and Punishment of Genocide Convention, right? So it has both those terms in there. So I think the biggest thing that can be done is documentation for civil society organizations. I think IAMC and its partners do a really, really great job of documenting that, putting that in reports, making sure they're engaged with US and EU entities to make sure that those foreign agencies know what's happening in these countries and that they raise those issues, so that, you know, for once, maybe we could have, and again, this isn't likely, right? Because civil society doesn't call the shots here. They can't say yes or no. That's for states and multilateral institutions to decide, but to put pressure on those institutions to finally get it right, because Professor Fournier is right. The thing we say about genocide is never again. And then it happens 10 years later and we say never again. And then it happens 10 years later and then we say never again. And we're continually in this cycle. So the only way to break the cycle, I think, is for, and in terms of civil society, is for civil society to climb that mountain. And it's a huge mountain, it's Kilimanjaro, of trying to have enough evidence and trying to have enough input to government agencies, whether it's US or EU, to make sure that they raise these issues with their Indian counterparts, whether it's through trade deals, human rights deals, whatever it is, and ensure that those issues are being addressed by their partners before there's a mass atrocity and before thousands of people are killed. That's, I think, the most important thing, collecting the data and sharing that data and trying to influence US and other governmental agencies to raise this. Because again, just like Professor Fournier said, this is up to governments to raise, right? And if governments have trading and overall relationships with India, which they do, because India is definitely a big trading partner and a partner for security for a lot of different countries, well then, maybe our job should be to try and influence our governments to raise this as a serious issue and to actually make this never again, instead of saying never again and then waiting for the next genocide to happen.
Yeah, I kind of also agree with what Varis said, Dr. Varis said just now about documentation. That is also the aim for this whole project going forward. And yeah, I am very glad that the question was put up there. We have a question from one of our hosts, Rashid Ahmad, and he would.
Sorry
Yes.
for interruption, but I think there's much more to say about the last question, and I just want to do that with 3 words, and that is information, awareness, and education. I think civil society has so much to contribute on that field, that level as well. Thank you.
Thank you. So the final question for today is from Rashid Ahmad, and he would like to know that how it seems, he says that it seems that the law is more on the side of the perpetrator than the victim. It's more shielding the hate speakers than the victim, but then how are we intending to change that status quo, or if we can at all do something about it as an academia or civil society, and academia or civil society together? Where do we go from here?
Well, first of all, be invited again in a year's time by the IAMC, of course, to discuss the state of play. But I think that what we need to do is simply try to a number of things. First of all, try in my specific line of work, human rights law, try to understand better precisely where the challenge is, because what I just described is a situation where you try to apply a system that has been developed over 60, 70 years by 2 people, 2 states, to actors who do not act in good faith, or at least, to put it a little less strongly, do not subscribe to all the basic tenets that are underlying that system. So you need to figure out what is their strategy and how, for example, if the Wojciech-Sadurski case ends up in the European Court of Human Rights, how would the court be able to dismantle that bomb? It could, of course, simply refer to the case that I described myself, but it could also be more elaborate in its reasoning and try to explain a little bit better where its reasoning came from in the first place, addressing that specifically to the situation at hand. So you need to also, as courts, pick up on the surrounding that you're functioning in, and if that surrounding changes, you need to adapt your reasoning. That's 1. And 2, I think that a very important element is actually connecting the 4 talks that we just heard. It seems that I do my stuff in my human rights field. Caroline does her stuff in the international criminal law field, but they don't seem to be sufficiently connected. And that's also something that you can work on. The type of things that Marcel mentioned in the beginning, these international declarations. How can all of these things be brought together to a more coherent whole? Is it possible to have a definition of hate speech that works both in the human rights field and in the international criminal law field? These are some of the things that I would pick up from a discussion like today.
If I could,
yeah, sure.
I was just going to say that there is this unique sort of question here that's a macro question about the way we look at rights. And I think the American perspective is very individual based. Individual right to free speech is what trumps everything. But I think there's other rights, like a community's right to equality, a community's right to security, a community's right to safety, and security. So I think that we can actually, if we were able to again do this comparative analysis and bring together the American perspective and make it more open towards the European or even the Indian or even South Africa's court has this concept of community rights, not just rights for an individual, but also for the community they belong to. So you have a right as an individual to have free speech, but you have a duty to not violate the dignity or the security or the equality of other religious minority groups or groups in general. So I think balancing and incorporating both of these concepts of individual rights to free speech as well as communities' rights, and how do we balance those two and bring them together instead of leaving them separate, which is what I think Rashid Bhai is probably having a hard time with, which is that it seems like when we look at it from an individual's rights, then we're only seeming to protect the person who's getting away with saying awful things and creating hate speech or hate crimes. But I think that for Americans and for Europeans alike, we need to come together and bring together these two concepts of individual rights, of course, on one side, but also community rights. And I think how do we balance those, and citizens have rights and duties. American constitutional lawyers don't really like that. They kind of prefer to say that you just have rights and the rights are absolute, and that's the end all and be all. I think that we can learn from our partners around the world, by the way, in India, in South Africa, and some of the constitutional courts that have recognized community rights as a duty to balance individual rights. That's, I think, a more positive way to look at it, and a way that we could actually bridge this gulf where it doesn't seem like we're using free speech to deny the dignity, to deny the safety, to deny the equality of religious minority groups. I think we can balance the two by bringing these two ideas together. Sorry for jumping in on that.
So in the interest of the time, I will take one final comment if anyone would like to, and then we can close this session here. Anyone? No? Okay, so I would like to thank all the four speakers and also IAMC for co-hosting this webinar. It was a very interesting webinar for me personally as well, and a big thank you to Professor Marcel Bruce, Caroline Fournay, John Moraine, and Boris Hussain. We're not in public, otherwise I would have clapped. We are online, so I don't know if that is the still a possibility. And thanks a lot to our attendees for being with us today and starting this conversation. Thank you.
Thank you and goodbye.
Goodbye.
Thank you. Bye-bye.
Thank you, everyone.